First thing, Albie, I want to say this is not a question, but just to speak on behalf of us all, and all who were there yesterday evening for the lecture, that sharing that session yesterday evening and this morning with you, I think is one of life's privileges. You touch something very deep inside each of us, and I think bring out in each of us what it means to be human. You don't meet very many people in life who have that effect, so it's a lifetime privilege to be able to share time with you. Kieran last night said that he empathised with you. The light was shining in your face. You were being bombarded with questions. You were wired up. So we're not going to pose that on you again this morning. We're going to have a much gentler, interactive session this morning. I know you've spent some time in Britain and you may be familiar with the radio programme Desert Island Discs. So I've read your book from front to back, and it's a bestseller in the making, for sure. And one of the things that came out of the book, or one of the many things, was that you said in one of the chapters that if you were sent to a desert island, you would take two constitutional elements with you. One was human dignity, and one was proportionality. And to me, they have a terrific resonance with all of us and all the challenges that we face as the four national human rights institutions in these islands. So I wanted just to start, maybe not so much a dialogue as a monologue, but prompted humbly by myself to begin to explore why you attach so much significance to these concepts of human dignity and proportionality, and then to open up the conversation as we set off on that exploration. But perhaps just from your own insights and experience, if you could begin to share some of your thinking on these concepts.
I suppose I mentioned those two items because they came to me as a surprise. I'd grown up in the, I'll call it the Anglo-legal tradition of parliamentary sovereignty, and the function of the law and the courts was to interpret what Parliament meant when it passed a particular law, and if it wasn't Parliament itself, if Parliament gave subordinate authorities the power to issue bylaws or regulations, were they within the framework of what Parliament said? So it was all a question of the vires, ultra vires, not ultra vires, and then we developed all sorts of what we called canons of construction, and they were very convenient because it was like Noah's Ark but pulling in opposite directions. The one canon of construction tended to favour the freedom of the individual and the rights of the people, and the other favoured the purpose and the objective of the measure and favoured the public power. And a crafty lawyer would take the judge through these possibilities and emphasise the one that produced the result that the lawyer wanted. That was the tradition in which I grew up. The impact of living in a constitutional state transformed all that, but we didn't automatically move from interpreting the intention of Parliament to the new modes of constitutional interpretation. And it's been quite fascinating to see how the British courts, under the impact of the Human Rights Act, have begun to adapt the approach to cases. One of our very brilliant law professors mentioned when we became a constitutional state that the effect was to move from a culture of authority to a culture of justification. A culture of authority is what did the lawgiver mean and say, and then there's some scope for softening and hardening the actual words used. The culture of justification is that legally permissible in our country? Does it interfere with rights in any way? If it does interfere with rights, is that interference justifiable? And I suppose most exercises of state power limit rights in one way and another, if you see a right as some kind of unlimited freedom to do certain things. And living in a modern regulatory administrative state, in fact, to be able to enjoy your ordinary rights, you've got to mix in with the rights of others. So regulation isn't, as some absolutist libertarians would say, inherently inimical to the expression of human needs. On the contrary, if I want to drive down the streets, I have to assume that there will be limits on other people driving in the streets, that people will stop at traffic lights, and it's that very regulation that gives me the freedom to move. So my freedom in that sense is conditioned on the existence of responsibilities on others, we living in a society and in a community. And the only question then, the basic question then is, are these limitations of the kind that are justifiable in an open and democratic society? And a speed limit of, I think it's 30, is it 30 in Edinburgh, would seem to be justifiable in an open democratic society, and it could be 35, it could be 40, it could be 25, and this is all within the scope of the reasonable authority. But if it said you could only drive at 5, it would become almost irrational. Then there's no point in using mechanized means at all, and it could be challenged on that basis. It's a totally disproportionate limitation of your right. I was actually introduced to the theme of proportionality, the term proportionality, by a German constitutional court judge called Dieter Grimm. He has become probably the world's leading expert on explaining German law to Anglo-Saxons and South Africans and vice versa. And he does it very beautifully. And I met him just as I became a judge, and he spoke about proportionality and the way it was used in Germany, and in particular in a case, it's a very poignant case, the abortion case. And in Germany, the issue of abortion is far more contentious. I mean, it's contentious everywhere in the world up to a point, but it was visceral and deep. And it was twice challenged, abortion laws, in the highest court, the Constitutional Court. And eventually the court decided it had to apply principles of proportionality on the basis that you can't say the growing life of the fetus counts for nothing, nor can you say that the life of the mother bearing the growing child and her decisions and her choice about the uses of the body and bringing a child into the earth or not counts for nothing, or that the one is greater than the other by definition per se. It all depends. And in fact, in a very beautiful judgment, the minority in the Second Senate of the German Constitutional Court said there are some problems that don't have a right answer. You can't say that through pure legal reasoning you come up with a correct answer. You have to acknowledge that the interests at stake are so powerful, they can't be fully reconciled. And so the court balances out as best it can. It does its best not to say that one principle annihilates the other, but to say that the best outcome we can give is as follows. And in the end, they acknowledge that abortion in the first trimester would be heavily dependent on the wish of the mother, properly counseled and with medical and so on. So the outcome is not all that different to what you find in other countries. But he stressed the importance of proportionality, and proportionality taking account of context. So you're not reasoning from classifications, from definitions. You're looking at how people are affected by a particular measure, its actual impact on their lives, and ultimately on their dignity as human beings.